Alex's team filed a motion for a new trial on Friday, October 27th. So here's what's new. Do you see it? Do you see that little number 1 I highlighted? That's the new thing. It's for a footnote. And the footnote reads, on October 17, 2023, the South Carolina Court of Appeals issued an order holding Murdoch's appeal in abeyance and remanded the case for consideration of this motion for new trial. That's literally all that's new. This is the exact same document they filed back on September 5th. Not only is there no new evidence or claims, they haven't even bothered to get affidavits from the 2 jurors who didn't submit their own affidavits. Those 2 that Dick's work wife, paralegal Holly Miller, wrote and signed. Those 2. They tried to explain it away in the first document that they hadn't had enough time to go back and get the affidavits from the actual jurors before filing, but that was September 5th, 7.5 weeks ago. That's plenty of time to get the actual jurors' affidavits. It's time to have collected more if the story is even accurate. Could Dick not bring himself to go down another dirt road? Could he not find his way back? Did he not want to get his car dirty again? What excuse does he have for not doing his job? I wonder how much he charged for adding that little number 1 and that little footnote and refiling the same document. Wouldn't you like to know? I noticed in several of my podcast videos, I say something irks me. So officially and for the record, this is the point in this podcast where I'm irked. I'm not a little irked. I'm big irked at this. Because it's all the same document, there isn't a whole lot to say about it. There's a line that's silly to me in here that says she did it to sell books that she couldn't have sold if there were a mistrial. This is absolutely untrue and just plain silly to say. Think about how many books were written after the OJ case. I think there was even more buzz because of his controversial not guilty verdict. Not long ago, I listened to the audiobook that Marcia Clark wrote about that experience, and I think it was more powerful because of the verdict. It's really a silly thing to say that the book couldn't have been written in the case of a mistrial. The book could have been written either way. If she did, in fact, affect the verdict, I think it would have more likely been related to her own belief in Alex's guilt and wanting to see him guilty. Not for her book. Controversy sells. And it would have been wildly controversial if there had been a mistrial or if he were found not guilty. If it were truly book sales as a motive, the more controversy, the more sales, the more people would have been interested in reading about what went on the inside. This to me is just not a good argument. My other irk is, I guess I have 2 irks in this one, all of this Facebook stuff. If they have not forensically searched this and been able to physically link it back to Becky, it's not even a legitimate accusation. It simply isn't, and there's just pages and pages of it with comments. None of it is relevant in the slightest if they can't link it to her. All it is without proof it came from her is a drain on my ink and paper budget. That being said, nothing will irk me more than finding out any of this is true about Becky. If she did this as a clerk of court and causes a whole new trial, she will be on my irk list forever. But I'm not going to comment anything more on that because I have read that 4 jurors have sought legal counsel to deny what this document claims. So until we have a hearing and get it sorted, it's all just speculation. None of us can say she did. None of us can say she didn't. So it's pointless to battle that at this point. Now that I've had my irk moment, there's also often something that makes me giggle in most of these podcasts. So for this podcast, here's my giggle moment. Imagine a day at the office as clerk of court, and you have to file a 74-page motion that's just full of your name and accusations against you. Yikes. The biggest trial Colleton County has ever seen, and you're the reason it might all be undone, and you have to sign and stamp the document with your name all over it. The irony. The first page, the signature page, and the certificate of service. And the certificate of service states that it was emailed. So did she have to print this out and scan it? I mean, how uncomfortable. But what I keep coming back to is that every single time Judge Newman sent the jury out, he told them not to discuss the case. Not to even discuss the case with each other. This was a grown jury. They weren't kids. They weren't very young adults. They were all adults. Did they not understand that? At one point in the trial, he even asked them had anyone tried to talk to them.
As I instructed you prior to us commencing yesterday with the opening statements, you're not to listen, watch, or read any news accounts of this case or discuss it with anyone or allow anyone to discuss it with you or in your presence. Has that occurred as to any jurors? All right, very good. It's very important that you keep that, follow that instruction.
They all said no. He was a very understanding, warm, approachable judge. If anything was going on, why was it not mentioned at the time? Why is it all this time later?
Received the evidence and heard the arguments of the state and the defendant. I will now explain to you the law that applies to this case. Under the Constitution and laws of South Carolina, you are the finders of the facts in this case. I do not have the right to pass upon the facts or to even express any opinion that I might have as to them, because this is a matter solely for you, the jury, to determine. As jurors, then, it is your duty to determine the effect, the value, and the weight of the evidence presented during this trial. You are to consider only the testimony which has been presented from this witness stand, along with other exhibits and evidence presented during the trial. Any other evidence or exhibits which have been made a part of the record you may consider, along with any stipulations made by counsel. You are also the judges, the sole judges of the credibility, that is, the believability of the witnesses who have testified and of the evidence offered. In considering credibility, you may take into consideration many things, such as the demeanor or manner of testifying, whether the witness had reason to be biased or prejudiced, and whether the testimony was contradicted on the one hand or supported and corroborated on the other hand.
They were given clear instructions. As I said, they were not children. Why didn't they do their sworn duty at the time if something was truly amiss? How dare they proceed, give a verdict, confirm that verdict, and then do this? They had every chance to say something at any point during this trial. Another thing I want to point out, I'm going to play the clip of when the egg juror gets dismissed. He is very clear in this that it has nothing to do with the Facebook post.
First off, this morning we have to deal with the issue involving the removal of a juror. A few days ago, I received a complaint from a member of the public indicating that a juror had engaged in improper conversations with parties not associated with the case. I communicated and provided a copy of the communications to the defense counsel. After court, we then met with the juror on the record, and the juror denied denied discussing the case with anyone not on the jury or with anyone on the jury. She provided information that led us to the court to contact the persons that she was suspected of having conversations with concerning the case. Those individuals were interviewed and provided an affidavit regarding the contact that the juror had with them. We then also brought those two individuals in and had a hearing in chambers on the record in the presence of counsel yesterday. In which both of those individuals waffled on the nature and the extent of the contact. They also provided a recorded interview, or the state provided a recorded interview with the jurors, and I reviewed that interview last night. So the juror has had contact or discussions concerning the case with at least 3 individuals. Though it does not appear that the conversations were that extensive, it did involve the juror offering her opinion regarding evidence received up to that point in the trial that the conversation took place. And in order to preserve the integrity of the process and the interests of both the state and the defense in a fair trial, that juror will be removed and replaced by another juror. And the court has not had any discussion with any SLED agents concerning this issue. All the inquiry by the court has been directly with the suspected parties involved and with the juror. But it is improper, it is contrary to my instructions to the jury daily, multiple times per day, and this juror unfortunately violated that order. I have, as you know, we've had some discussions with you over the past couple of days concerning indications of conversations with few folks not on the jury concerning the case and expressing some opinion about the case. I have reviewed everything, including statements given by individuals and recorded interviews, and concluded that despite my order to not discuss the case with anyone, that intentionally or unintentionally you've had some discussions with some folks not on the jury, and which is going to require me to remove you from the jury. No, I have not spoken with her today, but no, this is not related to, I know we also had some conversation was brought up concerning your ex-husband, but that's not a part of this consideration at all. This is totally independent of any other conversation that he might have had concerning you. That's not part of the order of the court.
And as for her tenants saying that they were coerced by SLED, the judge clearly says there was video taken of their interview. She was not released on minimal evidence or for no reason, and it was not SLED's fault. Those people are on video accusing her. Another clip I want to play. I listened to the verdict reading again, where they list out their juror numbers. Only 2 of the jurors in this motion were there for the verdict. The other 2 were dismissed before, not just the egg juror. And of the 2 who were actually there present and gave a verdict, only one of those provided their own sworn affidavit. The other one was provided by Holly Miller, paralegal.
Thank you. Madam Forelady and members of the jury, if that is the verdict of each and every juror, please let it be known by raising your right hands. All right, thank you. Any individual polling requested?
We do, Your Honor.
Madam Clerk, you'll need to individually poll the jury according to their juror numbers.
Number 193. Was this your verdict?
Yes, sir.
Is it still your verdict?
Yes.
Juror 254.
Yes.
Is this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 326. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 530. Was this your verdict?
Yes.
Is this your verdict?
Yes.
Juror 544.
Yes.
Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 572. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 578. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 589. Was this your verdict? Is it still your verdict?
Yes.
Juror 630. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 729. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 826. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 864. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Your Honor, the jury has been polled.
Thank you. The jury has been polled, and the verdict is a unanimous verdict.
It's very interesting that it was a juror who did not have a say in the verdict that spoke up first, as we see in this affidavit signed by Holly, prepared by Holly, not by this juror. So someone who was dismissed before the verdict is the first one to say something. Then we have the egg juror who was also dismissed and had no say in the verdict. And then they hunted down these other two, only one of which gave their own sworn affidavit. It is truly my belief that we need an evidentiary hearing before a whole new trial is declared. But I also believe Alex will be found guilty if we have 10 trials because he is guilty. That's really all I have to say about this, since I've already done a podcast about this motion when it first came out. But I wanted to give you this update that it has been officially filed as a motion for a new trial. I still have 3 other projects I'm working on as well, and hopefully I will get more time to get those finished and here for you soon. Till then, this is Cassidy O'Connell saying stay well and stay tuned.